recording this webinar. I will now start the recording and share the download link with you after the webinar. So what we'll have to do, we'll be discussing here with you is a number of topics. We'll, because it's for our English-speaking clients and business relations, we'll also be looking into the more general rules on holiday accrual, taking up holidays, and how to handle a payout of holidays. And when applicable, we'll look specifically to the Corona situation. All right, I will now move over and make some room for my colleague Mick, who is currently still on a safe 1.5 meters away, but will be moving into the seat. Thank you.
Hi everyone, good afternoon. Welcome again also on my behalf on this webinar about holidays. I will start with the accrual of holidays and the expiration or lapsing of the holidays. If you have any questions during our webinar, please please type them at chat and I will answer your questions during our webinar. The setup of this webinar from my part is that I will give you some questions we thought of before and I will give you the answers to it. These are the main questions we get in our practice on a daily basis. Just to start off with an easy one, how many days is an employee entitled to, holidays is an employee entitled to in the Netherlands? In the Netherlands, an employee is entitled to statutory holiday of 4 times the weekly working hours. So with a working hour of 40 hours a week, that's 20 vacation days a year. So a 40-hour working week is a 5-day working week. Most employees in the Netherlands receive some extra days. On average, it's about 5. So on average, in the Netherlands, a full-time working employee has 25 vacation days a year, and 20 of those are statutory then, and 5 of them are extra. And there's a slight difference on certain topics about the statutory vacation days and extra vacation days. We'll zoom into that on some relevant topics. Now, how does the employee accrue its holidays? An employee accrues the holidays over the days on which an employee is entitled to salary. The accrual of holidays goes proportionally over the year. So also during a holiday taken, an employee accrues new holiday. It's irrelevant if the employee is actually performing his activities. Also in case of an exemption from work, for instance, the employee accrues new holidays. There are a couple of exceptions to this general rule, namely that in a situation where the employee is not entitled to his regular salary, but still accrues holidays. And that's, for instance, on the statutory long-term care leave. Then there's no, by law, no rights to regular salary, but the employee still accrues holidays during that period of time. So is an employee allowed to take holidays, a holiday if he has not yet acquired sufficient holiday entitlements? Strictly speaking, the employee accrues holidays every working day, even though most people in the Netherlands look at it if you have, like, for instance, 25 holidays at the start of a new calendar year, but that's not how it works by law. So if you have, for instance, 24, that's easier for calculations, 24 holidays a year, then you build up 2 holidays each month, and so a portion of that one per work day. According to our Supreme Court, yes, this has been case law, it's allowed for an employer to refuse a holiday, a requested holiday, if the employee has not accrued sufficient holidays for the requested period of the holiday, of the vacation. So let's say an employee has used all its vacation days in 2019 and would like to go on holiday at the first 3 weeks of January, that's usually my situation, then the employer is by law allowed to refuse that requested vacation because the employee would not have accrued enough on his account, holidays on his account to have a 3-week holiday. And nobody, or it's not common to refuse a holiday on that specific ground, because normally the employer gives the employees at the beginning of a year the full holiday account for each year. So let's say the 25 days. Can the holiday accrual be included in salary? This is the so-called all-in salary. That means that an employee who works for a specific day receives salary, and for that salary, it's also included the payment for holidays, and most of the times also the holiday pay, the 8% holiday pay, which usually the employees in the Netherlands receive in May of any year. The European Court of Justice has ruled that all-in salary is in principle not in line with the European directive on holidays. Dutch case law, however, over the last 2 years is interesting, and it focuses on physical therapists who received an all-in salary based on an old collective labor agreement. That collective labor agreement is of 2009. It expired in 2009, but it still forms the basis of a lot of employment contracts for physical therapists in the Netherlands. Now, over the last 2 years, a couple of cases have been involved with the physical therapists who received a kind of all-in salary and now claim that they were still entitled to a payout of holidays. And the employer said, well, no, that's part of your regular salary. And it was part of the 2009 collective labor agreement, and that it's included in your contract. So you should have been aware of the situation that your salary was inclusive of the payout of holidays upfront. And Dutch case law now indicates that if it's been clear for the employee that the regular salary is included with the payout for holidays and also for the holiday payment, and that's an important second point of reference, the employee has been on holidays for the last couple of years, for instance, so there was no objection for the employee to go on a holiday, then it's allowed to use the all-in salary. But as an employer, you have to stimulate and motivate the employees to actually take their holidays. If you don't do that as an employer, then it might be that it's not allowed to use the all-in salary. So I don't know if there are any companies using all-in salary in this webinar, but if that's the situation, then based on the Dutch case law of the last 1.5 years, it's allowed to do so if you fulfill these 2 requirements. Next question, does an employee accrue vacation days during illness and or other leave? The answer is yes, insofar as the employee is entitled to his salary. This includes, so for instance, the periods in which the employee is incapacitated for work and the employer has an obligation to continue the salary of the employee. That's the normal situation, that the employee is entitled to his salary. Holidays are also accrued during pregnancy, childbirth, or an adoption leave. No holidays are accrued during parental leave unless other arrangements have been made in the employment contract or in the collective labor agreement. The parental leave is by law it's without pay. So in that situation, the employee does not accrue holidays. The expiration or lapsing of holidays. Statutory vacation days not taken by the employee lapse within 6 months after the calendar year in which the vacation days were accrued. So for example, holidays accrued in 2018 will expire on 1 July 2019, and now it's the situation that statutory vacation days of holidays of 2019 will lapse on 1st of July 2020, unless there has been made other arrangements, which is sometimes be done in companies, that there's a lapsing period for, let's say, a year instead of half a year after the year of accruing the holidays. Holidays in excess of the statutory entitlement expire after 5 years of the day of in which they are accrued. So for instance, the vacation days that are accrued on the 1st of March 2015 or the 1st of July 2015, they expire at the 1st of July 2020. But employees can interrupt the statute of limitations by informing the employer in writing that he continues to be entitled to holidays. So that's possible for employees for the extra days, but that's because they expire, and that's a different situation than the lapsing of statutory vacation days. That cannot be blocked by an employee, but it can be blocked by for the extra days. Should an employer actively point out possible lapsing or expiration of holidays? Yes, that's the situation after the European Court of Justice ruled that the employer has a best effort obligation on this topic. An employer must enable and motivate employees to take the holidays. He must also inform the employee of the circumstance that the vacation days lapse without compensation. If the employer does not comply with this obligation, European legislation opposes the loss of statutory vacation days. In that case, the employee retains the right to the holidays, even if the lapsing period has already expired. This ruling is from the European Court of Justice and is not yet followed in Dutch, in our case law, but because this whole legislation about holidays is of a European nature, the decisions of the European Court of Justice are binding for the Dutch courts. So it's very important for Dutch employers to actively motivate and stimulate employees to go on holidays and motivate and tell the employees that the holidays, the accrued holidays, will lapse within a half year after they are accrued. And if that's not been done, if the employer has not taken any action on this topic, then an employee can say, well, my days are not lapsed because the employer has failed to comply with the best effort obligation to inform me about the possible lapsing of my holidays. So this is an obligation for the employer to be taken very serious because otherwise holidays will not lapse. Are holidays due if the employee has not been able to take the holidays? This can, for instance, be the situation when an employee was not reasonably able to take the holidays. This can be the situation if the employee was not given the opportunity to take holidays by the employer. For instance, if the employer denies a requested holidays and not gave the employee a new chance in the year to take the holidays, in that situation, the holiday in that calendar year, then the lapsing of the holidays will not be the situation. And that happens more often if the employee was fully incapacitated for work, which means he's 100% sick. And if an employee is 100% sick, he does not have to take holidays, and those days will not lapse. So in the situation that the employee is 100% unfit for work, then the holidays will not, most likely not lapse within a half year after the calendar year in which they are accrued. Are self-employed persons entitled to holidays? A self-employed person is not entitled to holidays. After all, these are not employees under Dutch law. If, however, an assignment agreement states that the contractor or self-employed person is entitled to paid holidays, this is an indication that there's an employer-employee relationship instead of a contracting relationship, because paid holidays, it's something that employees are entitled of and not self-employed persons. So if you include that in a contract, in a service contract, then it's a point of reference for a judge to say, well, this contract looks more like an employee-employer employment contract than a service contract. And recently, for instance, I saw an agreement in which was stated that the self-employed person would receive a fixed amount per month, and he was obliged to work 47 weeks a year for 40 hours a week, which is of course the same as having 5 weeks holiday a year. Such contracts look like more like an employment contract, because that person needed worked for 1 full year, 47 weeks that year, and every month he would receive the same payment, so he would have 5 weeks holiday. Such contracts, such service contracts, are at risk if that self-employed person says, well, I'm actually an employee, look at my contract. Can I include an anti-potting clause? An employer and an employee can agree that holidays will preferably be taken in the year in which they are accrued, to prevent the accrual of an outstanding balance. This is so-called an anti-potting clause. The court of recent decision by the Court of Appeal in Den Bosch ruled that such a clause is not legally valid if it contains an expiry period for extra holidays that is shorter than the statutory period of 6 months for the statutory holidays after the year of accrual. So sometimes it's said that an employee is, for instance, allowed to take 3 holidays to the next calendar year, and that might not be allowed if that means that the extra days on top of those 3 days lapse within a shorter period of time than the statutory holidays will lapse. So an anti-potting bidding might be valid, but on strict conditions based on this decision by the Court of Appeal in Den Bosch. However, very recently, like a month ago, in one of our legal magazines on employment law, 2 authors, I analyzed the law on this subject, and they concluded that there's no basis for an anti-potting clause. They said it's not allowed to deviate from our law by including an anti-potting clause. So the case laws, recent case law suggested that it's possible, but based on this article of those 2 authors in the legal magazine, it doesn't seem possible anymore. However, a lot of employers include such a clause in the contract because most employees will at least think that they are valid clauses, and they will feel bound to such clauses, which will probably lead to the situation that they will just take their holidays because they might be afraid that they will lapse due to that clause in the employment contract, which might not be upheld in court, but still the employee does not want, most employees do not want to take the risk that they lapse. That's why a lot of these clauses are included in employment contracts. That was my last question I prepared for this part. I do not see a question in the chat, which means that I will give the floor back to Martijn.
Right. Moving on to the next topic, rules on taking holidays. Let me start off with the basic rules. So in any case, you should, as an employer, give the employee the opportunity to take the statutory entitlements. So that is, as a reminder, 4 times the weekly working hours, right? So that's for 20 days on an annual basis for a regular full-time employee who works 5 days a week. The next rule is that the employer will set the holidays in accordance with the wishes of the employee, which means that it's basically that the employee must indicate, and this is usually done via an online HR system, what his or her wishes are, and that in principle the holiday will be set accordingly. Third rule then is that if the employer has not responded within 2 weeks of that request, then the request is deemed to be approved. And I'll get to the deviations in a minute. The last basic rule is that on sickness during holidays. Suppose that an employee falls ill during his holiday. Because of that, if he wasn't on holiday, he wouldn't be able to do his job. If he's incapacitated for work, then the holidays must be converted into sick days from that moment on. Sick leave regulations may, however, stipulate that the employee must undergo a checkup by a local doctor. The UWV provides for a list of local authorized doctors in a number of countries. That could be something that you could implement in your sickness regulations. And also, it may have been agreed with the employee that his sick days will be offset against a balance in excess of the statutory entitlement. So again, the statutory entitlements say that it's 20 days and that the employee is entitled to 25 days. 5 days can be set off against the holiday balance. So the first 5 days of sickness can be regarded as holidays. Those are the basic rules. Now let's look at the deviations. The first one is what you can call important reasons. In Dutch, it's called gewichtige redenen, so heavy weighing important reasons. Basic rule is that the holidays are set in accordance with the wishes of the employee. So if an employer has important heavy weighing reasons to decline this request, then you can do so. So what are these important reasons? The law doesn't determine this, and the government initially at the end of the 90s, when this law was incorporated, the government meant a serious disturbance of the business. So you could, for example, consider the situation where in a seasonal company, employees want to take their holidays during the peak of the season, or the situation where in a small company would have be closed because it cannot be replaced. In order for the important reasons to be there, the employer's interest in rejecting the request of leave must be such that the employee's interest must reasonably deviate from that. So that doesn't bring us much further, right? And as a lawyer, what you do then is to check the case law. There's not so much case law about it, but there's one case that I will discuss with you. This is the Rotterdam ruling of end of September 2018. I'll shortly discuss what happened in that case. In February 2018, the employee booked a holiday to Indonesia from 17 October to 4 November 2018. Then in April 2018, the employee booked another holiday to Spain from 22nd September to 1st of October. In neither case, a holiday request has been issued by the employee. So he merely booked his holidays, booked the tickets, etc. So there was already some hassle between the parties, and the employee had called in a lawyer. On 21st of August, so that's already 5 months later, some 5 months, the employee's lawyer wrote the following in an email to the employer. He said, furthermore, on behalf of my client, I hereby pass on the following holidays: 27 September to 1st of October 2018 and 17 October to 5 November 2018. I would ask you to confirm briefly that these dates are registered with your clients. So, what did the employer do? The employer replied, well, this is something that your client should discuss with his manager. Then what you see in this ruling is that the decision has been made by the employer. And it says, like, as discussed during our meeting on 3 September and today of 11 September, you will be trained intensively in the coming months with the aim of being able to work independently at the beginning of December 2018. This process will be done carefully and your colleagues will be made available for this. I told you that from the first week of November, there will be a peak of work in the department because we are going to settle the heating season 2017-2018. This company was a heating company, or I think a company like Nuon. It is essential that you are then employable in the department. That's why I've decided not to approve your holiday request. Admittedly, I offer you the opportunity to take 1 week's leave, 29th October to 2 November 2018. This will allow me to grant part of your request. For this, I would like to ask you to submit a new application via ESS. After submitting this application, I will formally approve it. During our interim evaluation introduced in the upcoming months, we can see whether a 2nd week's leave in the month of December 2018 is negotiable. So what did the judge rule? The judge said, well, in this context, the employer has stated that it's important that onboarding takes place in September and October 2018, because from November onwards, there will be a peak period in the service cost department. In September and October, a colleague will be exempted from working in order to make this onboarding possible. From November 2018, no colleagues will be available for onboarding. Furthermore, a teacher that was involved in a course, the course payment of service costs and heating costs, was only available a limited period of time. The available dates both fall within the holiday period desired by the employee. At the hearing, the employer additionally argued that practice shows that an uninterrupted period of 3 months onboarding time is necessary in order to be able to work in the service cost department. In addition, the employee has indicated that she expects to need more time to familiarize herself with the job. So this claim, employee's claim was rejected. So there were, in this case, so-called important heavy weighing reasons. And the judge even ruled, the judge stated that the employee was negligible in booking her holidays without further consulting with the employer. If she would have done that early February, perhaps the outcome would have been different. So this is one good example of important heavy weighing business reasons. Another possibility to deviate from the standard rule that the employee's holidays are set in accordance with his or her wishes is that if you would agree otherwise upfront in a written agreement or in a collective labor agreement, in Dutch CAO. The original idea behind this possibility was to make it possible for employers to impose holidays during periods when the company is closed or when there is less work. So you could consider, for instance, the CBA, the construction CBA, the bouw-CAO, where there's the bouwvak. Bouwvak is the Dutch phrase for the construction holiday. So every season, I think in the month July, August, one of those months, there's a fixed period of time where construction workers are on holiday, and that's set basically unilaterally in the CBA. Now, if you're not ruled, if your organization is not governed by a CBA, of course, then your only possibility is to fall back on a written agreement, and that can be, of course, it should be an addendum or at least a written agreement with the employee. And in accordance with the text of the law, an employer has a lot of room here. In theory, it is possible to include in the employment contract or in an addendum that the employer always determines when holidays are taken. I think that such an agreement is not in line with the original intention of the legislator, and as far as I'm concerned, it also doesn't fit within the modern employment practices where flexibility is the rule rather than the exception. A more nuanced agreement is, for example, following: stipulate that the employee must take taken at least 3/4 of his holiday entitlements in the first 9 months of employment, for instance, and that the employer can unilaterally set days insofar as this has not been done by the employee. That helps a lot, right? And this is also in line with the legislator's idea that employees must recuperate and that both parties have a responsibility in this case. One other thing to know is that the introduction or amendment of a holiday scheme, a vakantieregeling in Dutch, requires the consent of the Works Council. If it's not possible to make agreements about the mandatory take-up of holidays, then at least make sure that the employee is regularly reminded of the amount of his holiday entitlements when these expire or lapse, and encourage the employee to take holidays. And a good approach is to actually ask the employee to come up with a concrete proposal on how he or she will take up the holidays. So it's if you do this on an individual basis, then of course the employee will be inclined to at least reply and come up with something concrete. Another option to deviate is the following: is to change the period after consultation with the employee. So this is where the holidays are already set by the parties, or at least by the employee eventually, of course. And then something pops up within the organization, and the employer would like to adjust the holidays. This is again possible only in case you as an employer can call upon these heavy weighing reasons. And if you can, you should also compensate the employee for any damage suffered, and that in practice would amount to the cancellation cost for any bookings made. Now onto the actual, so the most recent developments, Corona, and what impacts, or how relevant these holiday rules are in times of Corona. But we had a lot of questions on this topic. We decided to make a separate chapter. First of all, in the news the last weeks, we saw a lot of items on countries that are labeled yellow, orange, or even red. So what is that? Government has assigned color codes to countries, and these color codes, they indicate whether there are any special security risks involved in visiting such a country. And this is not something that was brought up or thought about around COVID-19. This is something that was already in place and has, of course, taken special meaning and importance in the context of COVID-19. So there are 4 of them. Green is where visiting a country has no particular security risks. And then the government says, well, take care of yourself and your belongings, just like you do in the Netherlands. Sometimes you have to pay extra attention to certain things. Yellow is labeled as pay attention, there are safety risks. A safety risk in this country or area that differs from what you are used to. Prepare for this and pay extra attention. Orange is only necessary travel. Serious safety risk in this country or area can lead to dangerous situations for travelers. The Ministry of Foreign Affairs advises you to only travel into this area if this is really necessary. Holiday trips are not necessary, and if you decide to travel away anyway, prepare yourself very well. And then we have, at least last year, we have code red: do not travel. Very serious safety risk can create a life-threatening situation for travelers. That is why the Ministry of Foreign Affairs advises not to travel to this area. Is then an employer allowed to refuse a scheduled holiday, taking into account these codes? There are 2 possibilities. Either the employee's holiday is fixed, was already fixed right before Corona, possibly, but the employer then needs the employee to carry out certain tasks. For example, many of the other staff are sick because of corona. I have to stay at home because of a cold. If the employer has important reasons and business operations will therefore be seriously disrupted by the employee's desired holiday, then the employee may still change the holiday period. And we discussed that a minute ago. In that case, the employer should compensate for the damage suffered by the employee. Now, suppose that the holiday has not yet been determined and that the employer comes up with a request to go on holiday. And then you can perhaps distinguish yellow, orange, and red countries. At least, well, to start off with the yellow countries, there's no ground to refuse a holiday to a yellow country. Orange countries, well, you can say that a holiday is not a necessary journey, and moreover, the employee must be quarantined after his return. But in our opinion, it's not possible to refuse a holiday for this reason. What can you do? Well, it's advisable to communicate what the consequences are when an employee leaves for such a country. And if the employee has to be quarantined and the work can be carried out from home, then in our opinion, you can argue that the employee still is not entitled to salary. And you can even argue that that may also account for countries that are labeled yellow. But do note that this is not something that has been established in case law already. So looking at red countries, also no ground for refusal, but at the same time, a situation like this is not likely to happen, right? I don't think there's any employee coming up with a request to travel to a country that is labeled as code red, set aside whether he can even practically arrange a travel to a red country. Many employers, if this happens, will flat out refuse if the employee informs them of the country where he would like to go. And I think, yeah, you may even get away with it by simply refusing such a request. But formally speaking, you don't have any say in where the employee goes on holiday. So what if an employee gets stuck abroad? Is he or she entitled to continued payment of wages? Well, as said, that would depend on the color code at the moment the employee leaves. Right to salary depends on the question in whose sphere of risk it is, the fact that it's not possible to work. And we've just touched upon at least I think it's very arguable or good to be argued that if there's the employee travels to an orange country, then gets stuck abroad, then you could say, yeah, there's no entitlement to pay unless the employee wants to take extra holidays. At the same time, you might even argue this for yellow countries. This is a gray area. Fortunately, we haven't had to deal with the pandemic before, but it is very important that if you would like to be able to call upon basically these salary measures, that you pre-inform the employees of your view on this, right? So to have a communique in place stating that if holidays are granted, what will be the consequence of being stuck abroad, not being able to continue your work. As an employee could possibly work from quarantine, you could also announce that the hours worked in quarantine will be paid. But I think this is something that you should look at a case-by-case basis, but because most people will not be able to work from a quarantine, especially not from abroad. So I would say if this happens in the Netherlands, it's still a yellow country. An employee is simply entitled to pay if he is compulsorily placed in quarantine. Isolation is in principle an employer's risk. What if the employee falls ill abroad? In that case, the holidays will have to be regarded as sick days, right? And the Gatekeeper Improvement Act, the Wetverbetering Poortwachten in Dutch, that will apply from that moment. Employee will be entitled to sickness benefits. You can't deny this unless you can prove that he or she has become ill on purpose, right? This is the exception to the rule. If you're sick, if you've been, if your intent has been to be sick, then you're not entitled to sick pay, and this is hardly ever the case. It's hard to prove, especially in this case when someone wants to go on holiday. I think it's impossible to say, well, you basically intended to get sick. Okay. So can an employer oblige an employee to go on holiday, vacation? Employers may not oblige employees to take holidays. They are also not allowed to designate holiday periods in principle, because the idea is that employees decide for themselves when they take holidays. The exception that has already been discussed is that in case of an employment contract or collective labor agreement, this may be done differently. And then the text of the CBA or the employment contract determines the options that are available to the employer. And just to distinguish this from holidays from other types of leave, this does not apply to time-for-time arrangements and ATV-dagen, or labor time reduction days. Then the regulations on that specific leave are decisive, so it doesn't have anything, is not governed by the same rules as holidays. Usually the collective agreement, the employee handbook, or the employment contract will stipulate how this time-to-time and labor time reduction take place and what the terms are. So the fact that employer cannot oblige an employee to go on holiday doesn't mean that employers every now and then try something. And so recently the employer called Billfinger tried, and this case was brought before court and is now published, and I think it's relevant to share it with you, and just to see how this practically works out. If you do try and say, okay, we oblige your employees to take up holidays. This is a Court of Rotterdam ruling of the 29th of May 2020. The employer had announced a number of measures in response to the government measures surrounding Corona. That it said in one of the letters they sent to the employees. The starting point is that staff members will take 20% of their time off as a holiday in consultation with their manager until the 1st of June 2020. If the customer's operation allows it at the discretion of the manager, employees in the operation will be asked to do the same. Article 20 of the employee's employment contracts contained a unilateral amendment clause. But as the judge ruled, this does not affect the fact that due to the article section 7.6.13, that is the clause on unilateral amendments of employment conditions in the Dutch Civil Code, that Billfinger may only invoke this provision if it has such an important interest in the amendment that the interest of the employee must basically deviate it from this in accordance with standards of reasonableness and fairness. So basically, again, you need to have a really heavy weighing interest. Now that the employee has not agreed to this unilateral change, it's up to Billfinger to substantiate its weighing interest in the measure. And a simple single reference to Corona is not enough. Moreover, this letter that I just quoted showed that this is a starting point and that this is done in consultation with the manager. At the time the employee had already been laid off, he was never consulted about taking his 20% of holidays. And against this background, Billfinger cannot unilaterally impose the employee to hand in 20% of his holiday hours. I think the best practice is with the lessons learned from this. Of course, it's done. You need to substantiate an amendment of employment conditions. A simple reference to Corona is not sufficient. So it's really up to a company to say, well, we are confronted with the Corona crisis. This affects our operations. Be very specific. What does it mean? What other measures have you taken? If then, if you then can argue, well, taking up holidays as a part of necessary operations to survive as a company, and perhaps also to avoid dismissals, then you have a case. But it's, yeah, in the case of Billfinger, they basically, they're very generic and did not specific enough. So that was not enough, and they lost this, this part of the case. The last question, can an employee withdraw a holiday request? If an employee wants to cancel his holidays, for instance, because he doesn't want or cannot enjoy his planned holiday because of the virus, should then an employer allow this? Well, case law points in different directions. On the one hand, Court of Appeal of Arnhem-Leeuwarden held that, in principle, the employee can be held to his stipulated holiday. However, if the employee subsequently wishes to revoke his holiday, he must consult with the employer, and the employer will have to behave like a good employer. The Court of Appeal in Amsterdam considers it contrary to the Dutch Civil Code to hold an employee to his stipulated holiday against his will. The employer, in accordance with the view of that Court of Appeal, must then have sufficiently weighing circumstances to refuse the withdrawal. In short, so there's no definite answer, but must be borne in mind that labor law protects employees and that holidays must have a recuperative function. In our opinion, employees will therefore be, in principle, be allowed to withdraw their holidays. If you're confronted with an employee with such a request, I would at least suggest to make specific arrangements on what will be the alternative dates for this employee's holiday. I don't see any questions in the chat. If you do have questions, do feel free to ask. You put them in the chat. I will now again move over and give the floor to Nick. Thank you.
The payout of holidays and also the value of one holiday, one vacation day. Not every employer knows that the value of one vacation day for an employee is more than just the base salary, as I will explain. First, we'll focus on the payout of a holiday during the employment relationship or afterwards. A couple of questions I have, and I've got the answers for you. Can an employee choose to have holidays paid out? Statutory holidays may not be paid out during the employment relationship, but holidays in excess of the statutory entitlement may be paid out during the employment relationship. The employee can therefore not choose to pay out statutory holidays during the employment relationship. It's only allowed for extra holidays. What arrangements are possible at the end of the employment? Upon termination of the employment, the employee is entitled to payment of the remaining vacation day account. So that's for statutory days and also extra days. And only if the parties have reached an agreement on this, days between the notice of termination and the actual termination of the employment contract can be regarded as days off. So that's usually agreed upon in a settlement agreement that the employee is exempted for work, and for instance, as a trade-off for the vacation days, so that during the exemption for work, it's considered that all holidays are deemed to be taken. That means that parties may agree, for example, that the employee is not longer entitled to payment of any outstanding vacation days. So that's important, for instance, especially for companies who might go to the UWV if they are going through reorganization or planning to go for a reorganization. If you have asked for permission at the UWV to terminate the contract, and you as a company unilaterally terminate the employment contract, then the employee is entitled to the payout of his vacation days at the end of the employment relationship. Also in the situation that the employee is exempted for work because there might not be any work for that employee anymore. So only if you make an arrangement in this on this topic in a settlement agreement, then it's allowed to trade an exemption for work for vacation days, for holidays. In the Netherlands, we have now the situation of a dormant employment. It's a slapend dienstverband in Dutch. That is about employees who are more than 2 years sick, who are still employed, who do not perform any activities anymore. Based on a case law of our Supreme Court, those employees now can request the employer to terminate the employment contract and pay the transitional payment, which is then compensated by the UWV. Such employees, that we call a dormant employee or slapend dienstverband, are they entitled to payout of holidays? Yes, they are. And it's against 100% of their salary. So also if the employee received 70% salary during the second year of the sickness, then holidays are paid against 100% salary. Also at the end of the employment relationship, and also for every employee, if the employee is during sickness entitled to a lower percentage than 100 salary during sickness, then if the employee takes a holiday, a vacation, and holidays are paid out during the vacation, that is against 100% salary. So that's important for all situations of sickness in which the employee receives less than 100% salary. During holidays, it's 100% salary. And the same goes for holidays that will be paid out at the end of the employment relationship. It's irrelevant if the employee received a lower percentage, for instance, in the second year of sickness. The first question, two questions pop up at the same time, but the first one, are hires entitled to the payment of holidays? So in a situation the employee ceases and hires, are they entitled to payment of holidays? And that's the answer to this question is yes. That's decided by the European Court of Justice 1.5 years ago. The second question is, can an employee transfer a remaining holiday balance to a new employer? Yes, this is possible for employees to transfer the outstanding holiday account to the new employer, and then at the former employer where the holidays are accrued, that employers should pay the salary for those holidays, and then at the new employer, the employee is allowed to take unpaid leave for those remaining vacation days, for those remaining holidays. It's not a situation that is often used in the Netherlands, I presume, but it is allowed by law. And can minus hours be deducted from holiday hours? No, that's not possible. So if the employee works less than the contractual hours, then it's not allowed to deduct those hours from the outstanding amount of holidays, unless this is agreed upon in the contract or in the collective labor agreement, but we seldom see those kind of arrangements. So if someone works less hours, that's might be possible at this moment of time during Corona, it's not allowed to deduct those minus hours from the outstanding holiday account of the employee. And what happens if there's a negative holiday balance at the end of the employment? That sometimes happens if an employee took a long holiday at the beginning of the year and terminates the employment contract, let's say in the first couple of months of the calendar year. Then there were not sufficient days accrued during the year, while there are a lot of days taken already. Then most of the employers deduct the salary of those extra vacation days, so the extra holidays that were taken before they were accrued, from the final settlement. And it doesn't surprise most of you that this has been subject of case law, and there's no clear answer to this, but what we see in the case law is that if the employer has informed the employee upfront about the possible deduction from extra holidays that are taken but not accrued from the final settlement, then it's allowed. So if you inform the employees within the organization that it's a possibility, then in most cases in case law, it's allowed to do so at the final settlement, final account. The last subject of today is the remuneration components that form part of a single vacation day. So what's the value of a holiday of a single vacation day? Holiday pay is a term that is regularly litigated about, whether or not as part of a more extensive procedure, for instance, a dismissal procedure of which payment of outstanding holidays is part. I wrote an article, it's in Dutch, about this subject 2 years ago, in which I analyzed the case law about the subject to give my opinion on which components should form part of a holiday payment based on the case law. And this case law is also from the European Court of Justice, and it gave a basic rule for it, which is that any remuneration component that is intrinsically linked to the work of the employee forms part of the holiday pay. And the basic idea behind this is that an employee should not suffer any financial disadvantage as a result of taking holidays. This could be the case if certain allowances, if certain wage components will not be paid during a holiday. But it's important to know that if the employee takes a holiday during the employment, the payment should be the same as at the end of the employment. So most cases are focused on the termination of the contract, and then there's an account for outstanding holidays, and the value of a vacation day is the same at the end of the contract as during the contract. And based on case law, I can talk for hours about the subject, but I will summarize it. It's safe to say that holiday paid as one single vacation day is the basic salary plus holiday allowance, a 13th month, a fixed end of the year bonus, a profit sharing, a regular bonus, commissions, and personal allowances such as an evening, weekend, or a night allowance, which are, for instance, in healthcare, very common. So all those components form part of the value of one vacation day. So a lot of employers think that it's only the basic salary, but that's not the situation. All those extra components form part of the value of one vacation day. Now, which not? European Court of Justice again says that only additional and occasional costs do not form part of the single vacation, the value of a single vacation day. In the Netherlands, in the Dutch courts has translated this into the reimbursement of a lease car. Also, if it's privately, the lease car might be used for private purposes too, and the reimbursement of expenses. Those components are in Dutch courts. It's not considered to be part of the value of a vacation day. There's a lot of discussion if the same goes for the employer's part of the pensions contribution. There was the first couple of case law was decided in favor of the employees, but now the last 3 cases are decided in favor of the employers, which means that there's now a shifting tendency towards the result that the employer's part of the pension contribution does not form part of the value of a vacation day for employees. And overtime is in principle not part of a vacation day, unless it's part of the agreement between the parties, this that an employee needs to make overtime. The overtime is performed regularly, and the remuneration for the overtime is an important part of the total remuneration of the employee. In that case, also overtime might be part of the vacation day, but the basic principle is that overtime does not form part of the vacation day of an employee. So this will have to be assessed on a case-by-case basis. What about reduction of working hours, ATV, or personal budget life hours? Both components are sometimes part of a collective labor agreement. Dutch Supreme Court ruled many years ago that reduction of working hours are not, it's open for parties to decide the value of such hours, which can also be zero. So an ATV-dag does not have to be of any value in money terms. For personal budget life hours, which are oftenly seen in collective labor agreements, the case law is again not 100% clear, but most case law states that it's up to parties to decide the value of such an hour or days. And most of the times it's then said that it's just the base salary is the PBL is just the base salary and not all extras, because a PBL hour is not the same as a vacation day. I see that there's a question in the chat. What if commission is not regular? Yeah, that's it needs to be decided on a case-by-case basis. If those components do form part of the holiday payment. If it's not regular, in the sense that the amount is not regular, then it might not be a part of the vacation, the value of vacation day. However, if the commission is on a regular basis, but the amount of the commission is not fixed, then it definitely forms part of the vacation payment. But it's safe to say that commissions, which are usually part of the total remuneration of an employee, that they are part of the value of a vacation day. So if it's just sometimes a commission is given, then it might not. There might be a case of stating that it's not part of the vacation day. But if it's part of the total remuneration package of an employee, then it will be definitely part of the vacation day, of the value of a vacation day. If there's any more questions about it, then I will see it in the chat. Because the last question I prepared is there a difference between statutory and extra statutory vacation days or holidays? No, there isn't. A lot of employers have tried to persuade judges into ruling that the European case law is only about statutory vacation days, but there's a very clear line in Dutch case law that there's no difference between the value of a vacation day for statutory and extra statutory vacation days. The amount is the same. So you cannot deviate this from how to set the value of a vacation day. It does not make any difference if it's statutory or extra statutory vacation day. And in a lot of collective labor agreements, it was decided, for instance, that the extra statutory vacation days that did not include some salary components, but the judges ruled that no, that's not up to parties to decide. This is mandatory law, and you cannot deviate from this by employment contract or by collective labor agreement. So if there are not any more questions, then I will thank you also on behalf of Martijn of being at our webinar again. This will be the last one before the school holidays starts in the Netherlands. So it will be a bit of a holiday period for us too. And we'll most likely be back with webinars or after in September or maybe the end of August after school holidays has ended. So if we don't see you guys before that, we wish you a very nice summer and see you guys later.
Ik had problemen in een vliegtuig met een mooie stewardess. Ik moest van Windows zuipen en ze lezen me de les. Maar ze hoeft niet bang te wezen, dat ik ga vandaag